और डैश, ये दो चीजें जब आप सावधान विश्राम करते हो तो ऊपर नीचे हो जाती हैं. डू दैट.
हाँ, ऐसे उधर बस बदली फासला होना चाहिए. हाँ, इधर आओ और बस सेंटर ही आपने गायब कर दिया. ठीक है.
Just relax and keep on moving your feet. हल्का हल्का. Relax. जब आएगा word of command, that time you can come back to सावधान.
थोड़ा सा काम को हिलाते काम को
I just adjust.
खड़ा होना पड़ता.
Guys, someone pull this. Come on.
I cannot if I move.
इसके ऊपर आनी चाहिए मैम. हाँ
ठीक है.
हाँ हाँ यस मैम. यस मैम. यही तो दिक्कत है. For the 10 minutes standing from that. This is the time will come out. It's the worst part. Mine just comes down. I don't know. So take a uniform.
जल्दी पी लो. ठीक है पानी पी लो. नहीं पीना. पैर हिलाते रहना. उंगलियां अंदर से उंगलियां मूव करते रहना.
हेलो हेलो मोबिन सर, मेरी वॉइस क्लियर है? ये कोडलेस माइक 4 है.
आराम से विपिन क्लियर है आपकी वॉइस?
हेलो मोबिन सर।
विपिन आ रही है आपकी वॉइस?
हाँ सर, मेरी वॉइस क्लियर है सर?
हाँ जी, हाँ जी।
Thank you.
सर ये कोडलेस माइक 5 है।
हेलो चेक 1।
हेलो।
ओ ओ चेक। ओ
Come on, guys! Come on, jump! No talking.
ॐ भूर्भुवः स्वः तत्सवितुर्भरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा ॐ भूर्भुवः स्वः तत्सवितुर्भरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा ॐ भूर्भुवः स्वः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा ॐ भूर्भुवः स्वः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा ॐ भूर्भुवः स्वः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा ॐ भूर्भुवः स्वः
Jai Shriman, Amity University, some 25 cadets, husband, hey! Jai Hind, Shriman! हिंद श्रीमान, सम्मान गार्ड को विसर्जन करने की अनुमति चाहती हूँ। जय हिंद श्रीमान।
ॐ भूर्भुवः स्वाहा तत्सवितुर्भरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा। ॐ भूर्भुवः स्वाहा तत्सवितुर्भरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा। ॐ भूर्भुवः स्वाहा तत्सवितुर्भरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा। ॐ भूर्भुवः स्वाहा तत्सवितुर्भरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् स्वाहा। ॐ त्र्यम्बकं यजामहे सुगन्धिं पुष्टिवर्धनम् उर्वारुकमिव बन्धनात् मृत्योर्मोक्षीयमामृतात् स्वाहा।
Yes, for NCC. Prepare.
We have got 5,000 students plus academic session, and they don't get to train any of our disciplines unless they complete that.
This is one of the respects in which Amity and my organisation, Harrow School, is alive, because Harrow has always been built on a philanthropic tradition going back over 450 years, and it's one of the reasons I think that the synergies between Amity and Harrow are so strong. Yes. Yes. So part of this purpose of this trip for me is to learn more about Amity. I came to see the Harrow International School in Bengaluru, but also this is a very important part of the trip to learn about Amity too. Yes, I saw on LinkedIn. I saw Dr. Atul with the
how we will display the value of inclusion. सब लोग बड़ा भी ज्यादा जरूर है ये काम
Yes, yeah. And do international students come to Amity on a long-term permanent basis, or is it just visiting specific projects? Thank you so much. Yeah. Okay, well, I would be let us come. Yeah.
The Amity School of Business offers programs in Bachelor of Business Administration, which is also offered by AIBS. So we offer programs across a number of technology, analytics, family business, entrepreneurship. These are like very popular programs
Yeah.
among students. And so we have collaborations with both University of London, University of Nottingham, University of Kiel, Queen Mary University of London. And the students actually go there, they do 1 year or 2 years there, and then they go there. And of course, we have the SAP programs and the 3C programs also. And okay, a lot of students are big entrepreneurs. So for instance, I don't know if you're in India long enough, there is a delivery partner called Shiprocket, and there is one of our students. And there is a EV manufacturer, he is one of our students.
Okay.
And so a lot of our students grow up
Yeah.
to be pretty good entrepreneurs from the Amity School.
Yeah. And are they building their businesses while they're here?
Yes. We kind of, so we have the incubation center also, we kind of nurture them to be entrepreneurs.
Yeah.
India as it is not very easy placement, but I think we do encourage students to become so that they can provide employment to our
Yeah,
and that is one of our mandates of
course.
the schools.
And in this changing world, do you find that the way of doing business is probably quite different from the way that we did business
It is very
in
different.
our generation?
And they are wired very differently actually.
Yeah, absolutely.
The way they
Yeah.
think and the way they operate.
Yeah.
Sometimes they find it very difficult,
Yeah.
Gen Z especially, very difficult to work in the corporate world.
Yeah.
They think differently and the CEOs think very differently.
Yeah, well, if you're anything like me, you'll find that you learn almost as much from these young people as they learn from me. In fact,
I have children of
possibly
their age.
sometimes slightly
Yes.
more.
So I have children that and I've learned to adapt to their way of thinking.
Yeah, absolutely. Yeah, it's very, very good. Keeps one young.
Yes, exactly. Okay, I have another school called the College of Commerce and Finance, and there we offer the BCom program and the MLC with the accounting and finance section.
Yeah.
So we have tie-up with ACCA. We offer ACCA.
Yeah.
So we offer about 7 exemptions right now.
Yeah.
And so a lot of the students offer this program. And then we also have a tie-up with ICAI. We offer the Apex body which offers the chartered accountants. So these programs, and then we have a similar kind of collaborations with University of London.
It's really impressive.
Thank you very so much.
Yeah. Okay. Sorry, just okay. Advising. Yeah, well, that's something to know that level of collaboration is going on.
So we are honored to have you here. I'm
Thank you.
Sunita Little. I'm Dean Science and Technology.
Yes.
And we have physics, chemistry, mathematics, statistics, and data science.
Yeah.
Along with nanotechnology, food technology, forensic sciences, clinical chemistry. So we have got vast departments who are totally oriented towards research, because all these are research departments. So we have been doing a number of projects with international bodies, for example, United Nations, IAEA, then Marie Curie fellowships, etc. And our students, after passing through these, they go to many of the reputed universities in US and UK for their higher studies. And we have been, actually our faculty members are all PhD students, they are all PhDs, all doctorates, and they have around written 1,000 to 1,200 research papers in very respected journals, and they are doing research on very upcoming and emerging areas. For example, we are working with UN for SDG goals like climate change, hydrogen energy, then clean energy. So all these are funded projects, and we have actually established a number of research laboratories with funding, with government funding. And then we have already having this program BSc with dual degree with Melbourne University, and then we are having.
This is a very strong program. This is launched with the University of Melbourne, where the first part of the program is in India, and then the second part of the program is in Melbourne. So they have the best one there. And last year, they also got the opportunity to welcome 300 students from Monash.
Oh yes. A great friend of mine is the dean of Monash. So that's very exciting. And as it happens, my son is in Melbourne at the moment, but not at the university. He's working at a school actually. He's just finished. He graduated from university himself.
We also having this. We are also starting our dual PhD programs with University of Holyoke, then University of Lakehead, Canada. So very international collaborations here.
Yeah, that's very impressive. Yeah. So. And another thing that struck me yesterday at Nauru is the degree of interconnection between the departments and how all the subjects are actually using the science and technology that is available, and that struck me as being a very impressive aspect of the technology education as well. For all students. See, I think, they must take it. Yeah, I think that's remarkably far-sighted, if I may say so. Yeah. I'm interested to learn more about that.
I am Gerard. I am the director of Amity Institute of Biotechnology. It is one of the largest biosciences institutes in India campus. We have around 2,000 plus students and 90 faculty members. Again, all our faculty members are PhDs and postdocs. We also have faculty members who joined us after doing their postdocs from Oxford. And so it's a very research-intensive institute. We have grants coming in from all the major government bodies of the country. We also have grants from Wellcome Trust. We are having very strong collaboration with London School of London School of Health and with Nottingham University. We have very strong collaboration with the Baylor College of Medicine. We have collaboration with institutes under NIH. So we're doing a lot of international projects. We're working in interdisciplinary areas. We have 5 centers within the institute. And these centers were created for the ease of research.
When you say 5 centers, you mean 5 centers on the campus here?
No, so the biotechnology is the umbrella.
I see.
And within the biotechnology, we have 5 centers like departments, but they're not watertight departments. There's a lot of crosstalk that happens. So there's one center which is concentrating on bioinformatics, vaccine pipelines, and making health tools and big data analysis and all of that. Then we have environmental and plant center, which is working on sustainable climate, sustainable agriculture. Then we have biochemical engineering on enzymes for industrial production and wastewater remediation. Then we have a very large medical biotechnology center, which is working on both communicable and non-communicable diseases, particularly cancer and neurodegenerative. And
most of our projects are funded by government, and we encourage our students to work in these research labs so that they get an exposure of research from a very, very early days when they enter the campus. And because they get involved in research, they publish. We have our students have co-authored publications in Lancet, in Nature Genetics.
That's very impressive.
That's
That's
really,
as good as
really
it gets
nice.
in your field.
Thank you so very much. I know
Thank
it's
you.
so much to share, but
So much information, but,
if you permit, we can
No, they can, the package, the package, because law,
इसमें से आ रही है
So I am also director of the IT School of Engineering and Technology, where we are offering various programs in engineering, computers, computer science, AI, artificial intelligence, machine learning, civil engineering, mechanical engineering, automobile, all the engineering that we are offering right now, and we have maximum number of students here, 5,000 students. We are accommodating locals. So offering UG courses, PG courses, doctoral level that we have. And we have many international collaborations as well. Recently, we have done with the University of Belfast. And Chester University, we are working on some project that is on how this soil erosion and soil things are happening. That kind of
PhD program with John Hopkins.
John Hopkins, yeah.
Okay, as I've already said, I think it's one of the really impressive things is the degree connectiveness between the departments. So you're teaching AI, I assume, to all students across the university, as I've heard. So everybody is going out ready to quit to deal with these new challenges, which I must say, in my field, are particularly difficult in some respects.
Right. So that AI
Engineering is one of our most reputed institutions.
Yes.
Focusing more on computer science,
Yeah.
AI.
we have
They
the
have collaborations with some of the leading universities of the world. Like they have a program, corporate program, John Hopkins.
last university we have done with Australia and US. Yes.
you have to finish your,
I will,
so I will.
Well, hopefully I'll get a chance to talk to your executive. Can I also say, and I said this yesterday, I think sign and well-leadership, there are so many ladies in senior positions at the university. That is a very striking thing, both in Bengaluru and here, and I think that's a sign of a very healthy organisation.
It's a feelings word now.
So the rest of the HOS, there will be 11th, 10th will be back here, so you will be there at that time examining HOS.
Thank you. I look forward. Sorry, I didn't get a chance to talk to everybody. Yeah, thank you. Yeah. So AI Amateur's been looking into. I'll show you something. Almost like vertical means we start with the follow the deep learning and machine learning models, and we go and you see like multimodal AI, language models, which are very latest things, which are large language models. Vertical alignment, we are starting from the basics of deep learning and machine learning. The next one is and sorry, this is something that I've heard that students across all the sectors are learning about AI, but I assume that they're surely not doing all of these aspects. These are purely for engineers. Sure. Yeah, purely for engineers and computer science. Yeah. The next slide is more interesting. Okay. The next slide is actually this is what is he says the horizontal spread out. Yeah. The mandate is that every student of this university should do a course on AI. Yeah. Okay. Even if he's an arts management or anyone. So for that we consideration that even if you do not have math, they have done 5,000 last 5,000 students have done courses. We have given is just theoretical understanding what is AI, and AI is hands-on. Like one unit is let's say AI application in document summarization, AI in your email management, AI in your office.
So those kind of subjects, those kind of courses are also given. Sure. So this center is supposed to cater to the need of the university is diversified. Yeah. We have so many different kind of programs. Yeah. So this is actually the mandate is given by chancellor. So there was a very popular magazine. Our chancellor sir was reading and it was very highly studied. Yeah. There was a magazine called The Week.
The week, yes, we have them in the UK.
Yeah, we had them, so in here. Because I was giving an interview, it was covered, two-page article.
Yeah.
So the highlight of that was that in damage university, you're not only pumping it for the vertically for the engineers and the computer scientists, but also for the non-technical. And if you have time, we can show you.
Thank you, Dr. Mehta. He's very annoyed with me, very unhappy. Yesterday when I called him, he said, you will be giving me half an hour. I said, total to what is half an hour?
May I ask a very quick question? Well, can you teach the students about ethical and sociological aspects of AI as well as technicalities of AI?
To very honestly, still we do not have a full course on ethics of non-AI, but there is a module. Let us say when we teach a course, there are some modules, but still we do not have a full course. We will start it this summer.
Do you know what? I think we may get more time because I may sign up for your course myself, so I can learn something.
Incidentally, I am teaching that ethics.
मैडम को दे दो। हेलो जी
This prototype one student is making. So what happens is that during rainy season, we all carry umbrellas.
Yes.
And when we go inside, there is a water dropping there.
Oh, yes.
Very problem.
Oh yes. Somebody's had an idea how to get the water off the umbrella.
Right. So he is making one station, docking station, where you can keep the umbrellas, and there is a fan also being fixed over there.
Yeah. The next thing will be to find out how to use all the water that comes off the umbrellas. That's the next challenge.
I have many examples actually. One machine we are making, continuous vending machine. So you need to spend at least 2 hours here. I would like to show you something. This is a manual peanut shelling machine.
Oh, good. I need one of those.
Yeah, because you put the peanuts and then just rotate it with the So these are all fighting robots. They are playing hockey. Football. They are playing footballs when we put them in the ground.
Amazing things. I could spend all day here. I really could.
And then this is the electronic section.
Thank you, Dr.
I have only half an hour to see the entire campus, so I'm so excited to meet you.
Please find some time to come.
I do love to. I love to. Yeah.
Just recently we organized one hackathon in banking sector.
Yeah. I'm sorry, yeah, I'm just very nice to meet you. I'm not sure if it's very difficult. Everyone wants assistance all the time. But we want Yeah. 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 Yeah, yeah.
We have a huge online library.
Yeah.
We can put about half a billion items.
Yeah.
Accessible for everyone.
Yeah.
Of the campus, but we do have great business.
Sure, sure.
Yeah.
Mm. And how long have you been with Amity now, Mayata?
It's more than 10 years.
More than 10 years.
Yeah.
That's proper service.
Yeah.
Yeah.
So like any modern university library, Europe or US and all, most of our operations are automated. There is check-out counters. There are total campus is Wi-Fi.
Yeah.
Then automated re-entry to the campus, the library. Anything that you imagine, all the databases like Scopus, Silent Array, management, all 24/7.
And so how much, I'm just trying to see how much floor space is occupied by the actual, the books part of the library. I can see that's the section over there. And taking up other levels as well. Yeah. These, I'm in your hands.
It's a 3-floor structure.
Yeah.
About 1,000 students can sit at a time.
Yeah.
And we have varied user spaces. We have a lot of pressure on admin, but people can also bring their personal laptop, mobile devices, and all these devices.
The students will have QuickBooks from the library, or they can take that out.
For new students, for faculty development part of faculty development programs, those activities like information literacy or whatever you want.
Yeah.
Those are part of the system which are like conducted on regular.
Yeah. That's another extremely impressive session.
I was just thinking what to speak, what to speak. And still,
Absolutely. I mean, it's one more floor, is it? Yeah. Please, yeah.
There are larger books are come.
So, I mean, I think it's really.
I was taking it right that
I agree.
This is all nothing. And you have, it looks like you have some door reports over there. Yeah.
And that's
And these would be all the Indian door reports, or do you have door reports from other jurisdictions too? Other jurisdictions as well. It's wonderful to see.
So all of that, the same This floor is entirely for the law, management, and social sciences. In fact, this is history. This is all entirely.
The sounds of the university provides these tablets.
Nowadays, every student entering university education system, they have their personal laptops and mobile devices. And now it's not a big deal.
Yes. Yeah.
I was capable of it.
Okay. We're doing the old fashioned. Makes sense. It's really like. It's old fashioned. Yes. In London. Yeah. Oh, well, that's okay. Yeah. Yes. Okay. Sure.
You can just imagine, so this entire campus is
Oh, it's awesome. Yeah. No, I could notice during the initial term you were very keen to start the tour, and I can understand why, because time is She was very keen to pursue this.
Yeah, absolutely.
You've got
practice. They practice acting and dancing. Like to practice something?
Thank you. To be honest, my dancing doesn't really need
some
practice.
hidden aspiration, something that you look like actually. So, Gagan, Dr. Gagan, we have very less training.
Yeah, sure.
Just photograph from
Oh, you look so wonderful. Thank you very much. I may have missed my vacation now.
People at home will be envious, for sure.
Also teaching about the manipulation of media, I suppose what John would call fake news. Yeah.
This is cheating, Gagan. You haven't given
Being a lawyer,
so you can just talk. So if you permit, sir, we can have a podcast with you.
yeah, of course.
We are just going to ask you.
Yeah.
Yes.
Sure. Yeah.
So, what's your philosophy? Contract law.
Dev Jani, he is a master.
Oh, the style will do alright.
And any.
थोड़ा सा पीछे जा आपने यहाँ आप
Sure. So sorry, just for the question again. Yeah. Yeah. Okay. Yeah. Yeah. Sure. Andrew Butler.
Dr. Devjani, I'm sorry, but we need to speak over. We had a few of the Bali
Or we take a move.
Andrew Butler, can you add KC at the end? KC stands for King's Council. That's the professional side of KC. Sorry?
That's it.
That's it, yeah. Yeah.
Good morning.
This
Sir's camera?
एक मिनट मेरी बात
Huh?
Andrew Butler.
Which one is this camera? Sir.
Sure.
Master camera.
You know, Dr. Ejani, we have not told Mr. Butler anything about it. So for him,
Ma'am, audio check, please.
Mic check, 1, 2, 3, 4.
And I request sir to please have audio check.
My check, 1, 2, 3, 4.
Ma'am, can we have your audio 1 second, please?
Mic check, 1, 2, 3, 4.
If audio is okay. Can we lock the frame, please?
Lock, sir. Lock, sir.
All the frames locked.
Helen, are you having the 2-shot for
Yes,
introduction?
ma'am, we are having a 2-shot with a master cam.
Sir, पूछे वो ठीक है?
मैम आपको
Ma'am, we'll start with your cam.
स्टैंड बाय
So I should look into camera or
Ma'am, cable is, please check the ma'am label cable.
ठीक है
Label cable.
Check.
Check, 1, 2, 3, 4.
देखो पहन लो जूमिंग कर लो
हाँ सर वही सर हाँ जी बोलो ओके हैंड मूवमेंट हो गया ठीक है
Yes.
ठीक है ठीक है
Stand by. Can you headphone, please?
सर
Camera frame locked.
लॉक
We are ready to start.
स्टार्ट
Start.
Good morning. We are privileged to welcome Mr. Andrew Butler, KC, to our Western University on this special day. And we are also privileged to have his small podcast over here in our new studio at K2 Block. Welcome, sir.
Thank you.
My first question to you is, when we say good faith and bad habits, how do you feel? What is your philosophy regarding that when you think that this topic is relevant in recent law?
Well, the topic, good faith, bad law, is about the question of the extent to which a contract is supplemented by considerations of general good contractual behaviour towards your counterparty. And it applies particularly where contracts run over a long period of time, and it's very difficult for the parties to see at the beginning of their relationship all the possible eventualities which might arise. The problem is, if you go beyond the pure wording of the contract, how much further do you go? And that's the issue which lawyers are grappling with at the moment, certainly in the UK, and that's the issue that I'm going to be talking to your students about later on today.
So, I always feel that we have the special term Gen Z, who are right now very prevalent, and what is your take on this kind of topic, good faith, bad habits or bad thoughts? Is it going to have any relevance on Gen Z?
Well, it's a really good question. I've just spent some time looking around this very modern and forward-facing university, and to take students back into the rather dusty world of law seems a rather retrograde step, so I do it with a little apprehension. But I'm reminded actually by Dr. Asim Jahan, who I was speaking to about on this subject yesterday, that what I'm talking about is actually the basis for everything, and whatever field of human endeavour these students find themselves involved in the future, it will be underpinned by contractual law, and the sorts of issues that I'm going to be talking about today will therefore, I think, remain relevant to them in the future.
So here in Amity University, we always talk about tradition that blends with modernity. And today, the world is such that these values are very important for self-growth and action. What is your view of our esteemed university and the budding lawyers who are going to come and make us lawful citizens?
Well, I'm yet to meet the budding lawyers, but on the basis of what I've encountered so far on my trip, having visited Amity Bengaluru yesterday, they are a very engaged, forward-thinking student body. The university itself is, I have to say, remarkable. It makes me think of my own education. With all due respect to my university, it was a rather traditional place. Here at Amity, you really feel that this is a university that's properly adapted for the modern world. And I've been extremely impressed with everything that I've seen so far.
Thank you very much, sir. And I hope you have enjoyed this special podcast, and podcasts unplanned are always successful.
I very much enjoyed it. Thank you for having me.
Thank you, sir.
Thank you so much.
So tell me, is this the start of a beautiful new career in television?
Please select.
Yeah. Oh, I'm so sorry. I'm so sorry. I need to stand very still so I don't. Oh, we should have done that before. Sorry.
Gaurav sir. Gaurav sir.
Thank you. So difficult to know which camera to take
So what do we see here? What do we see here? Okay, this is a booth. Team A, you will have to write Team A on your paper. Team B will write Team B. And whatever you see here would be this, whatever you see in this picture, you will have to write here. So there are 3 pictures shown here. And you will have to write what is your perception of this picture. And I will read out. And the best suggestion to this picture.
She's again one of the foundation pillars of that school. She's just going to show us some.
Good morning, sir. We're at Amity, and at Amity School of Fashion Technology, we are offering programs in fashion design, fashion technology, fashion communication, textile design.
I don't know if it's been explained to you that my daughter is studying in this world at the University of Arts in London.
Okay, wonderful.
So I myself, as you can probably tell, I'm not a master of fashion, but she will be very interested to see me.
We know you may be very keen to see our facilities also.
Thank you so much, Mr. Karan. Thank you, Dr.
You know, Mr. Butler's daughter is coming.
I didn't explain that.
Just mention that.
Only they said like, you know, please take him to that school also. He will be
School of Fashion.
School of Fashion.
Please come this way, sir.
Only 3-4 minutes.
Yes, sir. So we'll just quickly show. We have a beautiful infrastructure.
Actually, my problem is we have an upper limit of your lecture because
Is that, I mean, what time? I can't remember what time the lecture is taking place.
11:30.
11:30, okay.
Sir, I must tell you, we've got wonderful videos where students work on their projects and do illustrations. Then we've got garment manufacturing labs with Juki machines, the best in the world, you may be aware. And then we have 2 new labs which have been made. Those are sponsored by Government of India and the National Technical Textiles Mission. So those are for the development of textiles and technical textiles. And here what we motivate our students is for doing the entire work here, whether it is designing, it is constructions, it is selection of fabric, dyeing, printing. So you may be aware India has got a lot of beautiful crafts.
I mean, how much
We have all the crafts in the curriculum, sir.
Yeah.
Right from north, so this way please, I'll show you around. This is the garment manufacturing lab. So you can see students working. Students, please rise, welcome.
You're too kind, thank you.
I think let them continue. Let them continue.
Yeah,
please.
please.
Please carry on. Please carry on.
So these are the garment manufacturing
Good
labs
morning.
that we have.
Nice to meet you.
So students do all the work here, right? You can see them doing pattern making before they do the construction.
Yeah.
Then they are
Yeah.
cutting the fabrics here based upon the designs that
May
they
I be
create.
permitted to take a photograph
Yes,
for my...
sir, it will be a pleasure. It will be an absolute pleasure.
Okay, thank you.
So that you can share it with your doctor.
Nice.
We will share every video with you.
This way, sir. Please come. So you can see all these students are working on different fabrics, experimenting with fabrics, and we have separate dedicated labs for development of crafts. They do dyeing and printing also, and we've got all specialized machine also, right from button fixing to bar tacking to finishing and fastenings.
So, I mean, one of the themes of the morning is how forward-facing the university is, how it's accommodating. That's what led my question about in this world in particular, that those old-fashioned ways of doing things must be meeting new ways.
Yes, that's what we are trying. We
Yeah.
have everything in the curriculum, right
Yeah.
from traditional crafts,
Yeah.
how you integrate those into the modern practices,
yeah,
and how to
yeah.
develop modern
Yeah,
designs
yeah.
using all those crafts.
But also how to preserve those crafts.
Yes, you have to preserve.
Yeah.
That's very important. That's why we keep teaching students all the time.
Yeah.
I also take a similar course, which is
Yeah.
textiles heritage.
Yeah.
So we keep telling students it's very important
Yeah.
to make sure that our artisans are being paid rightly.
11:15
We
over.
buy those products also.
Yeah.
So that's
Yeah.
what our mission here is.
Yeah.
Please come this way.
Right. So I think any more
We'll
labs?
meet Dr.
No,
Joshi once, and then we take him
that's
to
fine.
technical
So,
textiles lab. Sir, which are those sponsored labs, है ना? If you permit, we can show them those also.
Actually late हो गया.
Bas, it will take 2 minutes to show the labs also. Sir, also.
You're doing a wonderful job of keeping me full on course.
Right. It's all under my command, so students are waiting in
This way, sir. Please come.
Good morning. Good morning. Nice to meet
केबल
you.
ब्लॉक से नीचे उतर रहे हैं. Right? Okay.
I don't think we have very much time.
Pradeep ji, Joshi, we will not be sitting here. We just came, so
We have to rush.
we need to rush actually. So he could see the labs. Actually, his daughter is studying fashion in London.
So my daughter is at the University of Arts in London doing a lot of the sort of work that your students are here. Yes.
Okay.
She turned her back on, we had probably a different study career in mind for her, but she's a very determined young lady and this was her passion. So I have to salute her for following her heart and going the direction she wants to go rather than her parents.
So this is one of the emerging area, I must say, fashion. And we do the programs in fashion and textile design both. So we have got labs you must have seen, and we have just set up our state-of-art labs with the support from the Government of India, which are the high-end labs for testing the textiles which are being used for the high performance. So that is something very.
We can just.
Yeah, we can just talk about. Yeah. You can just go.
Kill two birds with one stone.
Dr. Roshi is taking care of these three institutions: fine
Yeah.
arts, fashion.
So we do in fashion, we do fashion design, fashion communication, textile design, fashion management.
Yeah.
And in the fine arts, we do graphic. You see all these works.
Yeah.
Everywhere is a very good place for it.
And one
Masani,
part
this is a very good place for a place. If we can have it.
We can have a photograph here, sir.
With
Your daughter will love.
Yeah.
Yes. Which floor we have to go?
Ground.
Second. This is third floor. Thank you.
Photography they do actually. We just had a fashion show last week where they show their design collection. And we just take 2 minutes. These are our 2 labs. Labs for which people are asking. These are the art labs.
Good morning. Good morning, everyone. Some class is going on actually.
Technical textile. Work on the project. The end of the program, you have to come out with a design collection. Which they show in a ramp show.
Yeah, sure.
Which we have done last.
Yeah.
last
Okay. Okay.
Textile.
So the show has just happened.
Yes.
So now the next cohort is
Yes.
next preparing at the early stages.
Thank you, Dr. Joshi. So much to see. But
We must go. We must go. Very good.
which floor is this? First? This is first floor? This is first floor, no?
Okay.
Second floor?
ये सेकंड है आपको ग्राउंड में जाना
Law faculty is
लेफ्ट से जाना
Law
होगा
The podcast that we've just done, is that intended for
I will give a copy to you. But
I
it
mean,
is
that's
for
fine.
the, it was all random, sir. Only for the,
Yeah,
it
no.
was all random.
Yeah.
It was for
no.
the internal consumption.
It's fine, but with the reason I mentioned it is because with cases in my practice that are coming up on
So people will generally 2 to 4 member team there. So students based over but majority workshops and events which are all the workshop and all the events are focusing on so whatever we arrange it on the ground floor, we arrange it here, and it has a capacity of 35 to 40 students. This is our team since up to there. So we have a 10-member team which is one member per team, one member per other campus. Like in Lucknow, Gwalior, the other campuses, we have one member per team. But majority of the teams is
Again, it's a very innovative thing for a university to be doing.
We were the second university here, sir, to start with the incubation in this place. In 2004, we started.
This is why the committee wants to use it. Will you excuse me?
Sure, sir. यहाँ तो कुछ दिखाने के लिए नहीं है, ऑफिस है ना सर का।
हाँ,
Everyone is requested to please rise. With the permission of the dignitaries, may we begin the session? A very good morning to Honorable Andrew Butler, distinguished dignitaries, respected faculty members, and my dear colleagues present here today. It is an honor to stand before you on this occasion as we come together to witness learning, dialogue, and the pursuit of excellence. At the outset, it is my proud privilege to extend a warm and hearty welcome to our esteemed dignitaries on the dais.
It is a pleasure to welcome you all to today's special address. Such lectures serve an important platform for intellectual engagement and the meaningful exchange of ideas beyond the classroom. They provide us with the opportunity to broaden our perspectives and synchronize academic learning with real-world experiences, and also gain valuable insights into the evolving landscape of our legal field.
I request our law school chairman, Professor Dr. D.K. Bandyopadhyay sir, and director, Professor Dr. Shefali Raizada ma'am, to kindly welcome Honorable Andrew Butler with a token of gratitude. Can we please have a huge round of applause? Thank you, sir and ma'am.
Now, I would like to invite Honorable Chairman, Professor Dr. D.K. Bandyopadhyay sir, to present the welcome address. Sir is a multifaceted scholar, academician, administrator, and a visionary leader in India's education community. We welcome you, sir.
Thank you. Thank you very much. I think it is about to be good afternoon, but still I would say good morning to all of you. It is our great pleasure and privilege to extend a warm and heartfelt welcome to our distinguished guest, Andrew Butler. On behalf of the entire Amity universe, the universe which has been created by one highly respected man, a doyen of Indian institutional builder, not Indian, worldwide institutional builder, that is our Honorable Founder President, Dr. Ashok K. Chauhan. He, along with his highly visionary wife, Dr. Amita Chauhan ji, chairperson of Amity Group, and sons, very highly capable sons, Dr. Atul Chauhan, our very dynamic research and student-centric president, RBF and Chancellor, AUP, Dr. Asim Chauhan, additional president, RBF and Chancellor, Amity University, Rajasthan, Mr. Ajit Chauhan, deputy president, RBF, our foundation, and chairman, Amity University Online. Mr. Abhay Chauhan ji, senior vice president, RBF, Mr. Amol Chauhan ji, executive director, strategic operation, FPO, and daughter, Ms. Sabna Chauhan, who have created 12 universities, more than 15 overseas campuses, including 3 universities abroad at New York, USA, Dubai, Tashkent, and more than 15 international schools at different parts of the globe, including Harrow schools with your patronage, sir. Indian education sector owes a lot to them. We are truly honored to have you with us today to the beautiful campus with more than 35,000 students. Your remarkable contribution, depth of knowledge, and commitment to excellence have made you an inspiring figure in your field. Your presence here is not only a moment of pride for our institution, but also a valuable opportunity for all of us to learn from your experiences and insights. At a time when knowledge, innovation, and thoughtful leadership are more important than before in the VUCA world, volatile, uncertain, complex, ambiguous world. We believe that your words will guide, motivate, and enrich our understanding. The question of good faith remains highly relevant in the contemporary context. In an increasingly globalized and interconnected commercial environment where cross-border transactions are complex, contractual relationships are the norm, expectation of fairness, transparency, and honesty have become more pronounced than ever. This makes the debate not merely doctrinal, but deeply practical. Our students, faculty, and participants eagerly look forward to gaining from your wisdom and perspective. And our law school, with full of brilliant prospective lawyers, more than 5,500 law students are studying in the Amity University, Uttar Pradesh. And we have got all the programs. We call it BA LLB, BA LLB Honors, BCom LLB Honors, BBA LLB Honors, LLB Honors, and certainly LLM in different areas of specialization with PhD programs. As of today, we have got about 54 PhD scholars doing their PhD, carrying their PhD in this campus only. So the hall we are sitting over here has been decorated by many of the Nobel laureates. This is Moot Court Hall, is very famous. And on the 4 wall of this hall, it reverberate their messages, their vibrations, and we feel charged when we enter. This is also a creation of our Honorable Founder President, Dr. Ashok Kechwan. Today will be written, sir, as one of the red-letter days in the history of Amity Law School, due to your gracious presence in our campus. Your love, affection, and association shall always reverberate in the corridors of Amity Law School. I extend our sincere gratitude to you for accepting our invitation and taking the time to be with us today. We sincerely hope your interaction with our students will be both meaningful and memorable. Once again, welcome you, Andrew Butler ji, and welcome to all present over here. Thank you very much.
Thank you, sir. I am honored to introduce Honorable Andrew Butler. He is a leading barrister and joint head of chambers at Tanfield Chambers in London. After completing a Class 6 degree at University College, Oxford, he converted to law and was called to the bar in 1993. He specializes in commercial and property litigation with a focus on development disputes and professional negligence. He was appointed King's Counsel in 2018. King's Counsel, the title is awarded to senior barristers in the United Kingdom for their high level of professional skill and experience. His career includes appearances in the Supreme Court and being shortlisted for Barrister of the Year in 2020. He is also a qualified mediator and arbitrator.
Sir is the Deputy Chair of Governors of Harrow and an old Harrowian. He remains deeply connected to Harrow School as a current parent. During his time as a student, he captained the school's rugby and football teams. A lifelong sports enthusiast, Honorable Andrew Butler represented Oxford University in rugby and is now a qualified rugby referee. He serves as the president of the Old Harrovian Association Football Club. Today is a very significant day at Amity as we are privileged to gain insight from a globally respected legal expert. We very humbly invite Honorable Andrew Butler, sir, for the invigorative lecture. May we please have a huge round of applause?
Mr. Chairman, ladies and gentlemen, thank you very much for having me here today at your magnificent university. As with everywhere I've been on this short trip to India, I have been blown away by the hospitality and the warmth and kindness with which I have been received. I would only say that it's a matter of regret to me that the same hospitality was not extended to the England cricket team recently by the India cricket team. Just 7 runs more of hospitality would have been very welcome indeed. But congratulations to India, who were worthy winners of that magnificent match and of the tournament. It's a great honor to have been asked to address you today. Of course, it's not easy for a lawyer like me practicing in one jurisdiction to identify a fit subject for an address to aspiring lawyers in a different jurisdiction. Despite the close historical ties between our two countries, our law is not your law, and vice versa. But the subject I have chosen, which is the rise, fall, and possible rise again of an implied doctrine of contractual good faith in commercial contracts, will, I hope, be of interest to you on one or more of many different levels. Substantively, I think our law on the test required for the implication of terms into contracts, commercial or otherwise, derives from a common origin and is similar, if not identical. So my hope is that first and foremost, the cases I'm going to talk about today might provide food for thought were similar situations to arise in this jurisdiction. But the talk works on different levels too. You can consider the story I'm about to tell you as a cautionary tale against judge-made law and the knots into which the law can tie itself when a topic susceptible to this range of views enters the judicial consciousness. Or you can look at it as shining a light on the limitations on the concept of freedom of contract. It invites the question, to what extent should the courts be prepared to supplement or rewrite the bargain between competent contractual parties? Finally, if like me, your mind drifts to cricket approximately every 10 seconds, you can find a parallel for this issue in the debate about the spirit of the game. Should players be able to play it according to the strict laws without any quarter being given or taken? Or is there an all-pervading code of good behavior which requires one not to take advantage of the black letter wording of the rules? If so, how far does that code go? There is, in my view, a close analogy between that debate and the issue that I'm going to talk about today. I would also say this, that having spent some time looking around this university this morning and your sister university in Bengaluru yesterday, I am very struck by the forward-thinking nature of the education that you receive. The range of subjects on offer here and the way in which they are taught prepares you well indeed, I would suggest, for the modern world. And it's with some apprehension, therefore, that I drag you back into the dusty world of the English common law. But I console myself with this thought. that whatever field students at Amity go into, whether it be law or otherwise, all relationships will need to be developed in the framework of a coherent legal structure. And within this framework, some of the principles that I'm going to talk about today will remain, I think, relevant. Now, I believe there are cases decided in India which touch on the subject of good faith. Cases such as the Association of Unified Telecom Service Providers of India and the Union of India are, I think, recognized as articulations of such a duty, although from what I have read, this sounds as if it is more concerned with what English lawyers refer to as derogation from grant, the notion that one cannot act in such a way as to deprive one's co-contracting party of the substantial benefit of the contract one has entered with them. As we shall see, the way in which the contractual obligation of good faith has been interpreted in England is slightly different from this. Sorry, which one? Beg your pardon. Thank you. A lawyer unable to work machinery. How amazing. So our story really begins with the 2013 decision in a case called Yam Seng and International Trade Corporation. This catapulted the debate about the implication of terms of good faith into contracts into a prominent position in the minds of English commercial litigators. While the debate is yet to be resolved, it has never truly yielded that place in the intervening years. It's perhaps helpful to start with an exposition of what Yam Seng was about. It was a claim brought by a Singaporean company which had entered an agreement with a British company which gave it a license to distribute Manchester United branded fragrances and other products in certain regions across Asia, hence the logo that you see on the slide before you. The company Yam Seng made several allegations of breach, which it said justified them in terminating the agreement. These included allegations that ITC had failed to make products available as and when they came on the market, had undercut the duty-free prices agreed with Yam Seng by offering the same products for sale at a lower price in the domestic market of the same territory, and provided false information on which ITC knew that Yam Seng was likely to rely in marketing the products. Some of the allegations made by Yam Seng did not relate to express obligations of the distribution agreement. However, among other parts of their case, they alleged that the contract should be read as containing an implied term that the parties would deal with one another in good faith. Mr. Justice Leggett, as he then was, heard this claim and held that, and I quote, following the established methodology of English law for implication of terms in fact, close quote, there was no difficulty in implying such a term into ordinary commercial contracts. By the established methodology, he should be taken as referring to the two tests for implication traditionally cited by English lawyers, and I think also in common use here. These are that a term is necessary to give the contract business efficacy, or that it represents the obvious but unexpressed intention of the parties. He held that what the obligation would require was sensitive to context, but that it includes the core value of honesty, and that it also went further and extended to conduct which would be regarded as commercially unacceptable by reasonable and honest people. Mr. Justice Leggett indicated that so-called relational contracts, that is, contracts involving not simply one-off transactions, but a continuing relationship over a long period of time, requiring a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence, would be particularly fertile ground for the implication of such a term. It's fair to say that Yam Seng did not meet with immediate judicial approbation. The next case in which reliance was sought to be placed on the implied obligation was Hamsard 3147 Limited and Boots, decided in October of that same year. This case concerned a refusal by Boots, a well-known chain of high street pharmacies in the UK, to renew a contract by which it agreed to buy certain product ranges from a children's clothing supplier. Mr. Justice Norris rejected the attempt by the supplier to imply the term on the facts, holding that it was not obvious, in his words, that the parties would have intended a clause about good faith to form part of their bargain. He observed that he did not regard Yam Seng as authority for the proposition that in commercial contracts, it may be taken to be the presumed intention of the parties that there is a general obligation of good faith, or that there is routinely to be implied some positive obligation upon a contracting party to subordinate its own commercial interests to those of the other party. Now, those final words are particularly worth considering, I think, because this is, in effect, what the duty of good faith does. It requires a party to refrain from doing something which might be in its commercial best interests and is not expressly prohibited by the terms of any contract, because it would harm the interests of the other party to the contract if it were so to act. Put like that, it can be seen that the implication of such a term is a far-reaching step indeed. Mr. Justice Henderson then expressly agreed with those words in CareWatch Care Services and Focus Care Services Limited, a decision given a few months later in July 2014. However, in appropriate cases, judges did show themselves willing to adopt the line taken by Mr. Justice Leggett in Yam Seng. In the same month that CareWatch was decided, Mr. Richard Spearman QC, sitting as a deputy judge, held that in a case called Bristol Ground School and Intelligent Data, an obligation of good faith should be implied into an agreement between a provider of training to pilots and a publisher of training material, and that it had been breached by the publisher in anticipation of a falling out, surreptitiously accessing the training company's computers and downloading its training material for sale. Again, not conduct expressly excluded by the contract, but felt by the judge obviously to contravene the parties' mutual intentions at the time it was made. Another such case was D&G Cars and Essex Police Authority. The contract in this case was a long-term contract between a police authority and a vehicle recovery company tasked with recovering vehicles which had been used for the purpose of crime. It was alleged that the recovery company had surreptitiously taken vehicles thus recovered into its own fleet for onward sale back to the public, and this was said to have constituted a breach of the implied contractual obligation of good faith. In the view of the trial judge, Mr. Justice Dove, there were 4 features of the contract which particularly justified the implication of the term, namely the relatively long period of the contractual relationship between the parties. Secondly, the fact that the vehicle recovery company was acting on behalf of a law enforcement agency, requiring that the recovered property was itself treated with both honesty and integrity while it was being dealt with by the claimant and they were exercising the requirements of the contract. Thirdly, the property that was recovered and being handled by the claimant might in some instances require return to the public, and therefore its treatment, whilst in the hands of the claimant, was of the utmost importance. And fourthly, some of the vehicles which were recovered under the contract would themselves form part of the evidence for criminal investigations and potential prosecutions in which they might become exhibits. And he held that by incorporating a recovered vehicle into its own fleet, the company was in breach of that obligation. Now, this judgment also contained some observations on the content of the duty, again going beyond the strict limits of dishonesty. They were, Mr. Justice Dove said, obvious acts inconsistent with the maintenance of the long-term relationship of fair and open dealing. Then, in April 2016, the issue came before the Court of Appeal for the first time, albeit tangentially, in a case called Globe Motors and TRW Lucas. Arose tangentially here was because that case really concerned the construction of an express term of good faith in a long-term agreement. Nevertheless, the court saw fit to comment on the implication of terms in long-term agreements, expressing the cautionary note that an implication of a duty of good faith will only be possible where the language of the contract viewed against its context permits it. It is thus not a reflection of a special rule of interpretation for this category of contract. In other words, the court was saying there is no special rule for so-called relational contracts. Rather, one has to approach the question by the standard tests for implying terms. Now, the next case chronologically was in 2018, when Lord Justice Leggett, as he by then was, tried a case called Al Nahyan and Kent. You'll remember that Lord Justice Leggett, as Mr. Justice Leggett, was the judge who had tried Yam Seng. Al Nahyan was a dispute between two business people who were in a joint venture. The claimant, Mr. Kent, held that he had been induced to enter into a compromise with Mr. Al Nahyan in the course of this venture by unfair means, including threats and duress, and in breach of implied obligations of good faith which Mr. Al Nahyan owed him. Lord Justice Leggett, perhaps unsurprisingly, took the view that his decision in Yam Seng had gained traction and cited the two cases I've just spoken about, Bristol Ground School and D&G, in support of this. He did not, however, mention Hansard and Carewatch, in which, as I've described, the respective judges had adopted much more circumspect positions. Perhaps something of the case of looking at an issue through judicial rose-tinted spectacles. Having been unable to find that Mr. Al Nahyan had breached any fiduciary duties which he owed to Mr. Kent, Lord Justice Leggett did, however, hold that the joint venture agreement was a relational one in which duties of good faith should be implied. These, he held, had been breached by certain kinds of what he described as furtive and opportunistic conduct on the part of Mr. Al Nahyan, including entering into negotiations to sell his shareholding without telling Mr. Kent and using his position as a shareholder to obtain a financial benefit at Mr. Kent's expense. Then, a year later, came the case which probably represents the high watermark of the doctrine of implied terms of good faith. That was the case of Bates and Post Office, a 2019 decision. Now, the background to this litigation is important. It was litigation which arose out of a very high-profile scandal in the UK. Over a period of years, the Post Office prosecuted a large number of its sub-postmasters on the basis that the computer software they were required to use to maintain their accounts showed that they had been drawing excessive and unauthorized sums from their businesses. After many such prosecutions, leading to the criminalization and imprisonment of many sub-postmasters, it was revealed that the true culprit was, in fact, the computer software. Worse still, the Post Office and some lawyers who had conducted private prosecutions on its behalf knew of the shortcomings in the software, but had proceeded with the prosecutions nevertheless. The Bates case was the civil litigation to which this scandal gave rise. Judgment in it was given on the 15th of March 2019. Issue 1 in the case was formulated as follows. Was the contractual relationship between the Post Office and sub-postmasters a relational contract such that the Post Office was subject to duties of good faith, fair dealing, transparency, cooperation, and trust and confidence, with specific reference being made to the decision in Yam Seng? Now, it can be seen that that question contained two presumptions. First of all, a presumption that relational contracts were a recognized species of contract, and secondly, that terms of good faith were automatically required to be implied into them. Holding consistently with the premise of the question that there was a recognized species of contract in English law called a relational contract, Mr. Justice Fraser identified certain factors which he said were relevant in determining whether a particular contract fell into that category. These were that there must be no specific express terms in the contract that prevents a duty of good faith being implied. Secondly, that the contract will be a long-term one, with the mutual intention of the parties being that there should be a long-term relationship. Thirdly, that they would perform their respective roles with integrity and fidelity to the bargain. Fourth, that they would be committed to collaborating with one another in the performance of the contract. Fifth, that the spirits and objective of the venture might not be capable of being expressed exhaustively in a written document. Sixth, that they would repose trust and confidence in one another, but of a different kind to that involved in fiduciary relationships. Seventh, that the contract would require a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence and expectations of loyalty. Eighth, there may be a significant degree of investment by one party or both in the venture. And ninth, that exclusivity of the relationship may also be present. Now, among the many other points which could be made about this decision, and as we shall see, many have been in the intervening years, it might be thought that it is conducive to an unnaturally binary approach in which contracts which are long enough in duration to qualify as relational are imbued with implied obligations of good faith, while an identical contract, but of a lesser duration, is not. Put in crude terms, it could lead to lead in theory to a view of the law in which a contract for X months is subject to the implied term, whereas the same contract for a period of X months less 1 day is not. It is debatable, in my view, whether that can lead to a coherent or logical position. It's also the case that Mr. Justice Fraser, much like Lord Justice Leggett before him, rather swept under the carpet certain authorities which did not resonate with his view. Authorities in which contracts were held not to fall within the category of being relational were treated, nevertheless, as supporting the proposition that that category of contracts existed. It did not take long for cracks to appear. 6 months after Bates, Mr. Justice Fancourt gave judgment in a case called UTB and Sheffield United Limited, another case involving a football club. And this was one of 2 major decisions relating to a boardroom battle for control of that club. Again, implied obligations of good faith were relied upon, and it fell to Mr. Justice Fancourt to decide inter alia whether the underlying contract was a relational one. At paragraph 202, he sounded what might be thought to be a wise note of warning, observing that there is a danger in using the term relational contract that one is not clear about what exactly is meant by it. There's a great range of different types of contract that involve the parties in long-term relationships of varying types, with different terms and varying degrees of detail and use of language. And to characterize them all as relational contracts may be in one sense accurate, and yet in other ways liable to mislead. It is self-evidently, he concluded, not all long-term contracts that involve an enduring but undefined cooperative relationship between the parties that will, as a matter of law, involve an obligation of good faith. He went on at paragraph 203 to say that rather than seek to identify and weigh the likely indicia of a relational contract in the narrower sense used by Lord Justice Leggett, it's preferable to ask oneself first, as Lord Justice Leggett had done in the Sheikh Tahnoon case, whether a reasonable reader of the contract would consider that an obligation of good faith was obviously meant, or whether the obligation is necessary to the proper working of the contract. So there again, we can see echoes of the tests to which we're all accustomed for the conventional approach to implying terms. So what he's really saying is that the question of whether an obligation of good faith can be implied by those normal yardsticks of obviousness or necessity, rather than with an analysis of whether it's properly classed as a relational contract and then working backwards from there. In a much later decision, Phones for You and EE Limited in 2023, Mr. Justice Roth expressed agreement with this passage. Now, in between those 2 decisions, though, in terms of time, came a case which is certainly worth mentioning in this context, even though it did not involve implied obligations of good faith. That was the decision in Times Travel UK. It's worth having regard to this decision for 2 reasons. First of all, because it contains some observations about the place of good faith generally in the body of English law, and secondly, because it is a decision of the Supreme Court. Times Travel was a case where a travel agent had claims for unpaid commission against the defendant airline. It was driven to waive those claims by steps taken by the airline which were lawful, but in the nature of economic duress, namely a threat to withhold future business unless the claims were abandoned. Nevertheless, the travel agent's claim was dismissed at first instance, and the Court of Appeal upheld that dismissal. The Supreme Court, in turn, upheld the Court of Appeal. In doing so, it was observed that English law has never recognized a principle of good faith in contracting. Instead, it has relied on piecemeal solutions in response to demonstrated problems of unfairness. It's worthy of note that Yam Seng, the case that started all of this, was cited in the arguments, but not referred to in the decision, hardly a ringing endorsement of its status as the first step in a brave new world of obligations of good faith. In similar vein, sorry, I've just gone past my slide. I've gone right to the end of the talk, which you may be wishing I would do, but I'm not prepared to do just yet. There we are, that's better. There we are. No, it's got a mind of its own suddenly. In similar vein, in August 2022, the Court of Appeal handed down judgment in a case called Candy and Bochet, in which improbably a lawyer sought to argue that there was an implied duty of good faith in a so-called conditional fee agreement, also known as a no-win, no-fee agreement, which it had entered with its client. Now, I believe that CFAs, as we call them, are not permitted in this jurisdiction, but in England they are. So I should just perhaps explain what they are. They are agreements in which lawyers agree with their clients that if a case is won, they will be paid an uplifted, normally double fee, whereas if a case is lost, they will be paid nothing. They are controversial because, of course, they give a lawyer a financial interest in an outcome of the case, which obviously brings its dangers. And one of the problems to which they give rise is that of defining what constitutes winning. As any experienced litigator will tell you, it is not always obvious from an outcome of a case which side has won and which side has lost. In Candy, what was alleged was that the client had negotiated an outcome with his opponent which deliberately avoided constituting winning and thus triggering the lawyer's entitlement for a double or indeed any fee. Rejecting the claim, Lord Justice Coulson observed somewhat wearily that there had been something of an avalanche of claimants trying to establish that their contracts contained an implied obligation of good faith. But, he said, only a relatively few have succeeded. He did not, however, go so far as to say that there could be no such obligation. Rather, he emphasized, citing the UTB and Globe Motors case, about which I've spoken earlier, that the test for implication had to be met, and that the elusive concept of good faith should not be used to avoid orthodox and clear principles of English contract law. Candy was then cited with approval by a differently constituted Court of Appeal 6 months later in Quantum Advisory and Quantum Actuarial, a case in which I appeared, and in which I successfully resisted an attempt to use the implied term of good faith to enlarge express obligations found in a very long-term agreement which ran for a period of 100 years. And there matters really stood in terms of case law until 2025. Although of note, in January 2024, an article was published in Law Quarterly Review under the authorship of Professor Paul Davis and Philip Sales, that is Lord Sales, a member of the Supreme Court, writing extrajudicially. It's entitled Controlling Contract Discretions, Wensbury Unreasonableness, Good Faith and Proper Purposes. And for anyone who is interested in the development of this subject, I would recommend it as essential reading. The article was unusually excoriating about some of the decisions which had led the way to the promotion of implied obligations of good faith. For example, describing the approach taken by Mr. Justice Fraser in Bates as not a helpful one, and the decision itself as unconvincing. The authors express respectful doubt as to whether the quest to identify a clearly defined category of relational contracts can ever be a productive exercise. And then in August 2025, judgment was handed down in Ellis and John Benson Limited, another case in which I appeared. Ellis was a rather extraordinary case. It concerned a driving school franchise in East Anglia, which was run in a forthright fashion by its proprietor, John Benson. Mr. Benson had alienated some of his franchisees who had got together and asserted a right to terminate their agreements based on what were said to be implied obligations of good faith. These allegations consisted of various types of confrontational and aggressive behavior and a disregard for sensitivities to race, sexuality, and other similar issues. There was no allegation, however, that the defendant had failed to perform any of the express obligations of the agreement in terms of actually performing the things required of it as franchisor, undertaking marketing, building the brand, providing business support, and so on. There was also no allegation that Mr. Benson had been in any way dishonest. The allegations were essentially that he had behaved in a way which are best described as not very pleasant or socially acceptable. On this occasion, I did not succeed, as I had in Quantum, in resisting the implication of the obligation. The judge, perhaps constrained by earlier authority in the context of franchising and anxious of the consequences of exposing the whole sector to implied obligations of good faith, rejected the argument that a term should be implied in law. However, he accepted that terms should be implied as a matter of fact. In reaching this conclusion, he attached considerable weight to the respective bargaining positions and experience of Benson on the one hand and the various franchisees on the other. Turning to the question of breach, the judge rejected my submission that such obligations, if they existed, could only be broken by conduct which was dishonest or something akin to dishonest, and that in the formulation commercially unacceptable to reasonable and honest people, that first word, commercially, particularly mattered. It was, I submitted, much more to do with what could be described as sharp practice than just boorish or antisocial behavior. But the judge disagreed and found that many aspects of Mr. Benson's overbearing behavior were sufficiently egregious to constitute a breach. Now, permission to appeal against this decision has been granted by the Court of Appeal, which means in the English system that a judge of the Court of Appeal means that the decision has a real prospect of being overturned. And that for me is an exciting opportunity because it means that later this year, I shall be taking this issue, which as we've seen has been the subject of so much debate at first instance in England over the past 12 years, to the Court of Appeal. If the decision is upheld, it will represent, I would suggest, a significant extension to the parameters of the implied obligation of good faith as they have been understood up until now, and will breathe life into a class of action which had been showing signs of running out of steam. So that is the so far unfinished story of the implied obligation of good faith in commercial contracts in English law over the last 12 years. Where do we go from here? Well, as I've said, I'm excited at the prospect of the Benson case coming before the Court of Appeal, where I shall be trying to persuade them, of course, that relational contracts are not a distinct category of contracts to which special rules apply. There are, I think, at least two difficulties with recognizing that category. First, while the law is, of course, used to dealing with classifications of contract to which special rules apply, one might think, for example, of tenancy agreements, employment contracts, or insurance policies. These are categories which are understood and recognized beyond the legal profession and by the public at large. And save in one or two very rare cases where a question arises, it is always possible to know whether one is dealing with one or not. That doesn't apply to relational contracts. The question of whether or not a contract is properly described as a relational one may be, and I would suggest usually is, an extremely grey one. Secondly, and that being so, given that the boundaries of the concept of the relational contract are so nebulous, it seems to me to be artificial to apply a special rule to contracts which fall within that silo and not to apply it to contracts which do not. This seems to me to cause vastly different obligations to arise from contracts which in truth are extremely similar, depending on whether they are classified as relational or not. I do wonder whether the answer lies not in the question of whether there is an obligation to act in good faith towards a co-contracting party, but in accepting that there may be one and adopting a much more flexible approach to the content of that obligation. It seems to me that a contract that gives rise to a long-term relationship, I'll avoid using the label relational, offers much more scope for such an obligation to be breached than a short-term or indeed single transaction contract. And of course, where a contract is intended to last over a long period of time, it is the less straightforward to foresee at the time the contract is made all the various contingencies and factual circumstances which may arise and how the parties should deal with them. But that is not to say that an obligation of good faith is not to be found in those shorter term contracts in much the way that Mr. Justice Leggett has suggested. And as for Mr. Benson, I shall be arguing that even if his behavior was properly to be classified as boorish or antisocial, that did not justify his franchisees in walking away from their contracts. His behavior did not amount to a breach of an obligation of good faith. Far from being dishonest, he was searingly and sometimes painfully honest. In circumstances where he was not even accused of failing to comply with the express terms of his agreements, the remedy of his franchisees, if any, should have lain in the various forms of legislation which exist in the UK designed to curb antisocial behaviour. Ultimately, the question posed by the Benson case is whether a party should be entitled to walk away from a relational contract because they consider their co-contracting party to be a nasty piece of work. The answer, in my view, is no. That seems to me to be a recipe for the abandonment of contracts on a whim and to amount to a serious erosion of the sanctity and seriousness of such an agreement. In the meantime, and while we wait for the case to come on for hearing, I shall also be hoping that England can perform just that little bit better in T20 cricket, or, as the English Test team now refer to it, the longer form of the game. Thank you very much for listening. Now, I would be, of course, very happy to take questions either on the topic that I've just been discussing, or indeed if there's anything else that interests you about the practice of law in England. I appreciate that particularly in a large room full of people, it can often be a daunting business to be the first to raise your hand and ask a question. And I've found in my experience that sometimes when it's time for questions, the audience develops an unnatural interest in their fingernails and a lot of heads go down. But if there is anybody who would feel brave enough to put their hand up and ask a question, I shall be very happy to endeavor to answer it. Lady in the second row, I don't know whether there's a microphone that could be made available.
Good afternoon, sir. My name is Varya. I am from BLLB Honors 8th semester. I had a question regarding the Yem Seng case. We had discussed a lot of cases and 12 years has been passed since the case. So I wanted to know that if there is a genuine doctrinal shift or merely a judicial experimentation in this English contract law regarding the same.
Well, thank you very much for your excellent question. And I think the answer I would have to give is that there has not been a doctrinal shift. I don't think its implications can be described as being as far-reaching as that just yet. I base that answer particularly on one of the other cases that I referred to in my talk, the Times Travel and Pakistan International Airlines case, where, if you recall, I mentioned that in the list of arguments in the report, Yam Seng appears. And yet, I think I'm right in saying, I'm so sorry?
In the decision, it was not referred, but in the argument, it was listed.
Exactly so, yeah. So it seems to me that that was an opportunity for the Supreme Court if they took the view that there had been a doctrinal shift caused by the Yam Seng case to say so. And the fact that they didn't refer to Yam Seng at all, still less deal with it, seems to me to have been an eloquent, shall I say, view of their effect, their elegant expression of their view of the effect of that case. But thank you very much for your question.
Thank you.
Well, oh, there's another question.
Good afternoon, sir. My name is Vignesh.
Oh, good morning. Afternoon.
Yeah.
Sorry, I didn't see you.
I am from BBLLB Honors 8th semester. Sir, my question to you is that how significant was the reasoning of Justice Laggett in Yam Seng Limited case in challenging English traditional reluctance to conduct the good faith doctrine?
I think it was on one view very far-reaching. He drew on quite a lot of authority from around the Commonwealth, as English judges are accustomed to do. And he took the view, I think his words were that in his view, there was no difficulty in, as I think I mentioned, using the established methodology of English law in holding that there is an implied term of good faith. But I've thought about this quite a lot. On one level, that's a rather, it's a seductive position to adopt, because I think you're familiar, as we are, with the officious bystander. The officious bystander is a device used, I think, in implied terms in contract. If the officious bystander is at a negotiation and asks, you know, at the moment of contract, are you acting in good faith? Are you contracting in good faith?
The answer, I think, would of course be yes.
Yes.
But if the officious bystander posed the question in a different way and said, in the event that something happens which you haven't foreseen, will you be required to respond in a way that respects the underlying spirit of your contract, or will you be entitled to pursue your own commercial self-interest? That is a much less obvious answer to that question. The parties may disagree. They may also find it just too vague to answer. So I think there's a yes and no element to the answer to the question. Mr. Justice Leggett, as he then was, put the position very seductively in Yam Seng. Of course, parties are going to contract in good faith. But I think if you actually start to unpack what that means over particularly the long term of a for which a contract can run, the answer becomes less obvious. So again, thank you. I hope that answers.
Thank you, sir.
Good afternoon, sir.
Good afternoon.
My name is Sayamika from BLLB pre-final year, and my question to you is, do relational contracts mentioned in the case Bates versus Post Office indirectly indicates the introduction of good faith into English law?
Well, rather like the question that was posed in the Bates case, I think the presumption of your question is that relational contracts is a recognized species. I think that remains open to debate. And I would refer you in that respect to the article in the Law Quarterly Review that I mentioned, written by much more eminent lawyers than I, which question whether the hunt for a relational contract is an exercise which can be fruitful. My own view, for what it's worth, is that it is not a species of contract in itself, but rather, and I take support from this from what the Court of Appeal said in the Globe Motors case, you have to approach the question from first principles. With any contract with which you're confronted, if you're going to be considering implying a term, you have to be satisfied that the high bars for implication, that is necessity to give business efficacy or representing the obvious but unexpressed intention of the parties, are met. And I think the word of caution, which emerges quite strongly from modern authorities, is you do not start at the end, what I would describe as the end, and say, is a contract relational or is it not? And then work backwards from there to see what terms are implied. Rather, you just start, you take every contract on its merits and you ask those questions that you would always ask if looking to imply a term. So my view, for what it's worth, is that there is no such thing as a relational contract. Others might disagree, and that's why the debate continues and remains fascinating.
Thank you, sir.
Thank you. I think there was one more. There was a lady here in the third row who's stood up once or twice, who's never had an opportunity to ask a question. So perhaps we could call on her.
Thank you so much.
And as long as it's not a very difficult question, that is.
Yeah, sure. Thank you. My question is a kind of a contradictory one. Like in English law, recognizes relational contracts requiring good faith in practice, but refuses to recognize a general doctrine of good faith in principle, as mentioned in time travel case. So is this doctrinal resistance intellectually honest or just a semantic workaround?
Well, gosh, what a question. I mean, I think I wouldn't describe it as intellectually dishonest, but I think we are at a bit of a crossroads now, where there seems to be quite an even split in the judiciary as to whether there is a pervading doctrine of good faith. And that's why I consider that the Times travel case, although not directly on point, is an important case to cite in this context, because the members of the Supreme Court, and in the UK it's usually a 5-person court, It can be 7, but I think in the Times Travel case, it was 5. They spoke with one voice and they said, no, there is no general recognition of a doctrine of good faith. Rather, we have individual concepts like duress, undue influence, and perhaps in legislative terms, the unfair terms legislation that protects consumers, all of which deal, as the Supreme Court said, with piecemeal areas where the problem arises. But they spoke with one voice. That was as recently as, I think, 2021 from memory. It seems to me that their voices should continue to carry weight. But I don't represent any established view in this debate. There is no established view. I can only tell you what I think.
Thank you so much.
Thank you for your question.
Good afternoon, everyone. I am Yati Dharma from LLM program. Sir, my question to you is, do doctrines such as misrepresentation, estoppel, and implied terms make up for the absence of good faith in English law?
Yes, and I think those would fall into the category of the piecemeal solutions that English law has adopted. And you mentioned 3 very good examples: misrepresentation, estoppel, and the third one I can't remember.
Implied terms.
Implied terms, yeah. Well, I have a bit more difficulty with the third of those, implied terms, because I harbour doubt, as you've heard, as to whether the doctrine of implied terms can be used to address problems of want of good faith. But I think estoppel and misrepresentation certainly do. Misrepresentation, of course, only arises as a result of pre-contractual behaviour. And what we're concerned with is usually post-contractual behaviour. Estoppel certainly can arise in that context, but also duress and possibly 1 or 2 other remedies can as well. So I would perhaps agree with the first 2 of the routes that you suggested. The third one I would be a little bit more circumspect about, if I may.
Thank you, sir.
Thank you.
Good afternoon, sir. My name is Manmeet Kaur and I am from BBLLB Honors, 8th semester. So with due respect, my question to you is, how does a Pakistan International Airline Corporation case prefer economic jurists to deal with unfair behavior rather than the general principle of good faith?
Well, what the Pakistan International Airlines case did was recognize, I think, that there is such a thing in English law as economic duress. You'll have to forgive me, I haven't read it recently, so I'm speaking from memory here, albeit that on the facts of that case, it was not made out. But I think the Supreme Court, again, speaking from memory, were addressing a submission that the state of the law regarding obligations of good faith had reached such a point that lawful actions committed by a contracting party, which were nevertheless in the nature of economic duress, should give rise to a contractual remedy. And I think the point that they were trying to make was that the approach of English law to good faith has not gone that far yet. So they were essentially resisting the imposition of an umbrella which, so to speak, joined the disparate parts of what they described as the piecemeal solutions, and saying, no, it's still the piecemeal solutions which govern the position. And if you cannot bring your claim within those piecemeal solutions, your claim fails. It is not good enough simply to say, my co-contracting party has not acted in good faith, therefore I should have a remedy. It's still necessary to bring yourself within those solutions, and if you can't, as the unfortunate travel agent in the Pakistan International Airlines case could not, then your claim fails.
Thank you.
So I'm Mayuk Roy from the PhD course. One question that I have is that Lord Leggett is executing currently what we see controlled demolition of the Yang Seng judgment that was given by him. So if that is the case, then why so is being done after he's being promoted to the Supreme Court? And if that's the case, one question also arises that do High Court inventions live on borrowed time till the Supreme Court actually pushes them into obsolescence?
Yeah, thank you. So it brings us on to perhaps a more general question of English law. I mean, obviously, the Supreme Court remains the ultimate voice in the English system. But in fact, it's when there's a Court of Appeal decision that it becomes binding on judges of first instance. I don't know whether the doctrine of precedent works in the same way here. But what's a matter of surprise to me is that despite all these cases that we've been talking about this morning and this afternoon at first instance, nothing really has yet got up to the Court of Appeal until, as I say, this case that I hope to be doing later in the year. So it doesn't necessarily have to wait till Supreme Court level, but just some authoritative statement of the law from the Court of Appeal would, I think, be very beneficial in the English system and maybe more widely as well. But thank you for your question.
Good afternoon, sir. I'm Varuni from BLLB 8th semester, and I would like to ask, do you think that other countries should follow the reluctance of like English law towards the good faith, or they should like go or adopt for a broader approach?
I think it would be a bit presumptuous of me to say what other countries should do. It's quite presumptuous of me to say what I think English law should do. I think these sort of things and the law generally is rooted in any number of profound cultural issues, you know, history of a country, the social mores of a country. And I think what represents a coherent body of law in one jurisdiction does not necessarily represent a coherent body of law in another jurisdiction. Now, I suppose in countries which are or were Commonwealth countries, there is perhaps a tighter affinity because a lot of the law derives from a common source. But I have noticed that if we take the particular example of Australian law, even in the time that I've been in practice, it tended to be the case that Australian judges used to look at what was happening in England and do the same. Then we got to a stage where Australian judges would look at what was happening in England and might do the same or might not. Now it seems to me they generally look at what's happening in England and do something opposite. So, you know, things develop in different ways. And if you'll forgive me, I don't think it's for me to express a view on whether one view of the law or another is better in jurisdictions outside England. I may have gone too far even in expressing my views about what's right in England as well, but thank you.
Thank you so much.
Mr. Andrew, this is our brilliant students.
Brilliant students.
And look at the way they are questioning.
I have to say
that they listen to your lecture.
Yeah.
Not heard, but they listen to your lecture and immediately formulate the questions.
Yeah, it's brilliant. It's almost as terrifying as being in front of the Court of Appeal, in fact.
I would have loved to have more interaction, but due to the paucity of the time, let us proceed for the next.
Of course, of course. Thank you.
See.
Thank you again. Thank you very much. Thank you.
Thank you, sir, for such an insightful and thought-provoking lecture. We express our gratitude to you for visiting our institution and delivering your precious discourse. Let's have a huge round of applause for sir once more.
We would now like to invite Honorable Chairman, Professor Dr. D.K. Bandyopadhyay, sir, and respected Director, Professor Dr. Shefali Raizada, ma'am, to present Amity Shield to Honorable Andrew Butler as a token of regard. Can we have a huge round of applause?
Thank you very much. I shall treasure it. Thank you.
Thank you, sir and ma'am. I would now like to invite respected Director, Professor Dr. Shefali Raizada, ma'am, for summing up the session and to deliver the vote of thanks.
Esteemed dignitaries, dear faculty members, and dear students, it is my privilege to propose a vote of thanks. Before vote of thanks, I would like to sum up today's deliberations. Good faith, bad law, the rise and fall of implied obligations of good faith, Sam Yang PTE Limited versus International Trade Corporation Limited. The position of good faith in English contract law reveals a deeper thought within English jurisprudence between the pursuit of fairness and commitment to certainty in commercial dealings. The decision in Yam Singh PTE Limited versus International Trade Corporation Limited marked a significant moment in this trajectory. By recognizing the role of honesty within commercial relationships, it reopened the debate on good faith within a system that has traditionally resisted the recognition of any overarching doctrine. Yet, what has followed is not a complete transformation. English law continues to proceed with caution, preferring incremental development within established doctrinal limits rather than embracing a broad and general principle of good faith. This reflects a conscious judicial choice to preserve predictability and stability in commercial transactions. At the same time, the question of good faith remains highly relevant in the contemporary context. In an increasingly globalized and interconnected commercial environment, where cross-border transactions and complex contractual relationships are the norms, expectations of fairness, transparency, and honesty have become more pronounced than ever. This makes the debate not merely doctrinal, but deeply practical. For Indian students of law, understanding this development is especially important. Indian contract law, though rooted in the English common law tradition, often adopts a more flexibility and equity-oriented approach in practice. Engaging with English position on good faith allows us to critically evaluate whether a stricter emphasis on certainty should prevail or whether broader principles of fairness should play a greater role in shaping contractual relationships in India. What we witness, therefore, is not a decisive shift, but a carefully controlled evolution, one that reflects the enduring character of English contract law, pragmatic restraint, and attentive to the delicate balance between fairness and certainty. Sir, your discussion on the traditional reluctance of English law to adopt a generalized doctrine of good faith contrasted with the emerging judicial recognition of concepts such as honesty, rational contracts, and implied obligations was particularly illuminating. Your insights into how courts subtly integrate good faith through doctrines like misrepresentation, estoppel, and implied terms have made the subject both accessible and intellectually engaging. More importantly, your lecture has encouraged the students of law to question whether the rigidity of the classical principles can or should adapt to modern commercial realities. This perspective is invaluable, especially for those of us aspiring to engage with transnational legal systems and comparative jurisprudence. The law may be built on rules, but its legitimacy rests on fairness. And that is where good faith quietly endures. Thank you so very much, sir, for such an insightful and thought-provoking lecture. It has given us a lot to reflect on. Now coming on the formal vote of thanks. At the very outset, I would like to express our profound gratitude, first of all, to our visionary founder president, Sir Dr. Ashok Chauhan, whose unwavering commitment to excellence in education continues to inspire generations. Sir, it is because of your blessings, foresight, and dedication that we are provided with such invaluable opportunities and platforms to engage with global thought leaders and expand our academic horizons. Today's session has been truly exceptional, and for that we owe our deepest thanks to our distinguished speaker, Mr. Andrew Butler Casey. Sir, your lecture on good faith and bad faith in English contract law has been both insightful and thought-provoking. Your nuanced exploration of how English law traditionally resists a general doctrine of good faith, yet increasingly recognizing its functional equivalent, whether through implied terms, relational contracts, or equitable principles, has given us much to reflect upon. Thank you so very much, and I extend my gratitude to our esteemed guest and leadership. Further, I convey my regards and thanks to our Honorable Chancellor, Dr. Atul Chauhan, sir, for his unparalleled vision and untiring zeal to scale great heights in the area of education. Thank you so very much, sir, for expanding Amity Universe, equipping with innovation and research. Further, my gratitude to Mr. Abhay K. Chauhan, Senior Vice President, RBEF, for his continuous guidance and focus on transforming Amity University into a world-class university. Thank you so very much. Thanks to Mr. Amol Chauhan, sir, Executive Director, Strategic Operations, Founder President Office, for his valuable contribution to the institution's growth and motivating young minds towards global level education with sense of values. I extend my gratitude to Honorable Vice Chancellor, Professor Dr. Balwinder Shukla, Amity University. I convey my thanks to ma'am for her leadership, for your leadership and academic vision for bringing Amity education landscape to greater heights and giving all support to make this event a grand success. Thank you so very much, ma'am. My heartfelt thanks to our chairman, Amity Law School, Professor Dr. T.K. Bandyopadhyay, for his constant encouragement and guidance for execution of each and every component of this event in the best possible manner. Thank you so very much. I would also like to extend my heartfelt thanks to all the additional pro-vice chancellors, group vice chancellors, deans, directors, heads of the departments, and faculty members whose efforts ensure that such academic events are conducted seamlessly and successfully. Very special word of appreciation goes to our wonderful student audience. Your attentive participation and intellectual curiosity are what truly make such sessions very, very meaningful. Finally, I would like to thank Amity Administration, Media Department, IT Department for their efficient coordination and all technical support, without which this event won't have been possible. With this, I once again express our sincere gratitude to everyone present here today. Thank you so very much.
Thank you, ma'am. With this, we come to the conclusion of today's lecture. We once again thank our esteemed guests, honorable dignitaries, and everyone present here. We request everyone to please remain seated till our guest proceeds further. Can we have a huge round of applause for our esteemed guest?